A teacher accused of sexually assaulting her 11-year-old student was hoping a Wisconsin judge would throw out her charges. Madison Bergmann was just weeks away from her wedding when she was accused of making out with a fifth grade student. The 24-year-old former elementary school teacher was arrested in May, originally charged with one count of first-degree sexual assault of a child. That is until 9 additional felony charges were added just last month. According to authorities, the allegations came to light when the mother of the 11-year-old boy caught him on the phone allegedly with Bergmann. After taking away the boy's phone, she discovered text messages between the two. When the parents uncovered the text, the boy's father reportedly stormed into Rivercrest Elementary School with printouts of the conversations. That's when police were called to the elementary school. The fifth grader reportedly told investigators he spoke with Bergmann almost daily, and he got her number when he went on a ski trip with his family and she was invited. Bergmann confirmed that she received the boy's number on that trip, but said it was in case they were separated while on the trip. When authorities spoke to her at the elementary school she worked at, they found inside her backpack a folder with the 11-year-old's name on it containing many handwritten notes. The boy told police he and Bergmann would write each other notes throughout the day, which revealed the two wrote about kissing each other. In one of the letters, Bergmann allegedly wrote, "One of my cousins is in the fifth grade, and I can't imagine a man talking to her how we talk. I know we have a special relationship, and I do love you more than anyone in the world, but I have to be the adult here and stop." When investigators reportedly asked Bergmann about the text exchanges, she lawyered up. She was arrested and let out on a $25,000 signature bond. The fallout from her arrest was swift. At the time she was placed on administrative leave, she was barred from contacting any district students, parents, or staff members, and her wedding was called off. A friend told the New York Post her fiancé was reportedly embarrassed she cheated with a little kid. But after her arrest, more disturbing details came to light. One parent told the New York Post Bergmann moved the victim's desk next to hers so she could touch him during class without other students seeing. When it was time for lunch, Bergmann allegedly asked the fifth grader to stay after class, as students initially thought the boy was just in trouble. The boy confirmed to police that Bergmann would have him stay after class, and he said Bergmann would kiss him several times in her classroom, either after school or while the other students were out to lunch. Then in September, more disturbing texts came to light when Bergmann appeared in court, when her lawyers tried to get her charges dismissed. Her defense reportedly argued the charges should be thrown out because the boy's text messages weren't specific enough about how he and Bergmann were touching each other. During last week's court appearance, more text messages were revealed in court, including messages where Bergmann allegedly said she wanted to lick the young boy's abs. The judge read in court some of the messages Bergmann allegedly wrote. One allegedly from Bergmann said, "I love having my hand on your chest. I could feel your heart beating so much." The fifth grader allegedly replied, "It was beating so fast. I was so surprised and I loved it because you just kept kissing me." She then allegedly wrote, "When everyone was cleaning after reading, I was standing at the front and you were too, and I touched your chest. When I grabbed your shirt and I pulled you into me, oh my goodness, I wanted to lick your abs." Bergmann's defense tried to argue her behavior didn't rise to the level of sexual assault because the boy used the word chest in describing their physical contact. Her defense attorney argued under the Wisconsin statute there had to be touching of an intimate part in order for there to be sexual contact, and the statute doesn't say the word chest or chest area. But the judge reportedly responded, "It would be absurd to require a child to use the same language that the state legislature has chosen for our statutes." And the judge ruled the word chest doesn't mean the boy wasn't assaulted, meaning the charges weren't dismissed, and Bergmann will have to stand trial for charges including first-degree child sex assault, child enticement, and sexual misconduct by a school staff member. I'm joined now by criminal defense attorney and former prosecutor Florina Altschuler. Now, Florina, thanks for being here to discuss this case, which is just very disturbing. A woman in her mid 20s telling a young boy she wanted to lick his abs and was kissing him in class in school. What's your reaction to hearing an elementary school teacher allegedly kissing and exchanging these sexual messages with an 11-year-old boy and a fifth grade student?
Yeah, Elizabeth, thanks for having me. 11-year-old boy. I mean, a child, very, very clearly a child. There really is no gray area here. This is just not appropriate criminal conduct. And there should be absolutely no tolerance for behavior like this. And there should be no tolerance for somebody to be in a position of power in an academic institution with access to children.
And what do you make of the defense's argument when they were trying to get the charges thrown out, that specifically the defense saying under Wisconsin statute, there has to be touching of an intimate part in order for there to be sexual contact? They say those parts include the breasts, buttocks, anus, groin, and other parts, but they say that the statute doesn't include the word chest or chest area. What do you make of that?
It's a technical argument. They're not wrong. It does not make it less inappropriate or any more okay. Uh, Technically, in order for there to be a specific crime, the facts of the case need to match each and every element of the crime charged. And every state defines its laws differently. However, the crime is going to be more severe or more serious depending on which body part is touched and in what way. In other words, whether there's just surface level touching or if there's penetration, penetration, of course, being much worse. So crimes are defined legally by those key elements. The facts, of course, have to match those elements in order for there to be a crime. If the facts don't meet those elements, it doesn't meet the burden of proof for that crime, then that crime was not committed. That does not mean that a lower level crime was not committed or that the conduct is acceptable or appropriate or that somebody who's engaging in this type of conduct, assuming the allegations are true, is somebody who should be working at a school or teaching children.
And what are your thoughts on the judge's response to that argument when he reportedly said it would be absurd to require a child to use the same language that the state legislator has chosen? What do you make of that statement?
Right. So the question is, what was the conduct in actuality, right? So the legislature will very clearly say, genitalia or penis, vagina. Children, the younger they are much less likely to use terminology like this. Here we have an 11-year-old. Now, what is the chest? And are we talking about breasts or on a male child? Does that meet the legal standard? Now, what the judge is saying here is that aside, right, a child is not going to use legal terminology when they express exactly what happened and what body part was touched. Most often across the country, what we see in cases of sexual assault involving children is children are taken to a special child advocacy center where specifically trained investigators and counselors speak to that child in a non leading way. Oftentimes, they use dolls and ask the child to point to, show, and demonstrate what was touched by who and how. And then it becomes very clear, and that's video recorded, it becomes very clear of what body part contact there was without the issue of the child using or not using words that specifically meet legal language.
And what do you think was, I guess, going through the defendant's mind when she was exchanging these types of messages with an 11-year-old child? I mean, I just I just can't even fathom that even happening. But what do you think could have been just going through her mind treating this young boy in such a sexual way?
So the problem here is reasonable people will very obviously say this is absolutely not appropriate behavior, period, end of story. What we have here is somebody who is not acting reasonably, who is not following what most normal average people would say is not appropriate. And the issue is when people like that work in schools, they have endless contact, appropriate contact with children, right? Through the nature of their normal, appropriate relationship. But then what happens is they cross a line from what was normal contact, they become close and they almost forget. And you might say, how can you forget? There's nothing, this is an 11-year-old, it's a child, it's visually apparent. They're in elementary school or middle school. Like, what's there to even think about? This is not something to forget. But for purposes of simplifying this, they forget the age of the child because of the nature of where their relationship develops. They become close. And then it gets into this area of what was initially appropriate contact, communicating about school related activities, to inappropriate contact, to contact through inappropriate means, right? Not just communicating in a classroom with other students there, but having one on one contact, having contact outside of school, having contact through text messaging, through Snapchat, through social media. There's really no reason that a teacher should ever have contact with a student through those sorts of means.
And do you think that this case would have been treated any differently at all if this was a male teacher with a young female student? Do you think that if it was a male teacher, they would have been given $25,000 bond?
We are seeing, unfortunately, more and more female teachers engaging in this kind of behavior. It's hard to know really whether there's disparate treatment among defendants, whether it's a male defendant or a female defendant. There is, unfortunately, the social perception that when a young boy has sexual contact with what society might say is an attractive female teacher, good for him, great. We're talking about a child here. We're not talking about a 19-year-old boy who's of consenting age. We're talking about an 11-year-old boy. So whether he's with a hot young teacher or an obese 50-year-old teacher really should not make a difference, because an 11-year-old is not capable of consenting. An 11-year-old is not an adult. An 11-year-old is not mature.
And Madison Bergman, she will face trial in this case. What could that trial look like, and which will be more important for the case on the prosecution side, the boy's testimony or the text messages and maybe even call logs as far as evidence goes?
So, oftentimes, when we have child victims, it's difficult to believe them. The stories are pretty incredible. We would like to believe that this egregious conduct is not something that somebody in a position of power, especially a teacher, would do. Most of the time, in these sex cases, the offender does not necessarily have a criminal history, and they have a good professional job. They're trustworthy, they're likable, and so it becomes a he said, she said. And children can give inconsistent stories. Children can exaggerate. Children can be mistaken. The younger the child, the more difficult they are to believe. In a case like this one, what's very helpful is those phone logs and those text messages. Because here, when the child says, she contacted me and said X, there's a text message that supports that what this child is saying is really true. Or we met up on the third Monday of this month. There's a call log with a call between the two around that time. And so the more objective outside evidence there is to support what this child is saying, the more believable the child is. The text messages alone may not prove the case, because the child will have more information about what actually happened in terms of physical contact that's not documented. But that story is going to be very believable when everything else checks out.
And I can't even imagine what this young boy is even going through. In your experience, how hard is it for these victims in these types of cases, speaking with investigators, telling the story over and over again? And again, just even with that potential of having to take the stand to discuss this furthermore, what is it even like for them to kind of go through something like this?
Right. It's a great question, Elizabeth, and there's no good answer to it. It is never easy. Even a child who appears on the surface to be well adjusted and to be reacting well, underneath the surface, there is no way that they are processing all of this easily. This is not something that is easy to process, to deal with, and to heal from. And it's something that many children, if not all children, carry with them for the rest of their lives. Some develop good coping mechanisms. Some have access to counseling early on. Some have very good family support. Some have positive role models and friends who encourage them and let them know that this was not their fault. And they have an easier, although not easy, time really making peace with something this horrible. Other children, unfortunately, lack support. They maybe don't have good family members who are supportive of this. Sometimes there's people in their lives who don't believe them, who question them reporting this. Sometimes they don't have access to counseling or early on. And then what you see happening is they start acting out in school. Their grades begin to drop. They may not want to go to school because that place reminds them of what happened. Their peers might be criticizing them. Sometimes there's peers who hold the assailant, the person who did this, the teacher or whoever else it might be, right, in high regard, and don't believe that that person could have even done this. And then they have resentment to this child for making this report. Sometimes they believe that it's a false report, and then there's hatred for this person causing all of this. So it's never an easy situation, and it's never something that is easy to just close that chapter and move on from. Testifying at trial, which often happens a year or two later, really is like ripping that band-aid off the wound just as the child is starting to finally try to at least heal, overcome, and close that chapter. They now have to relive it in detail, tell their story, and be subject to cross-examination by the defendant's attorney and be questioned about everything and essentially be accused of making it all up, of lying, of having some sort of ill motive, of being biased. It is not an easy thing to go through. So oftentimes the prosecutors will want to offer a plea deal and have the case resolved short of trial in hopes of avoiding having to have this child testifying. Many times, however, there is no plea deal and the case does go to trial and the child has to testify.
And do you see the defense putting Madison Bergman on the stand to essentially tell, I guess, her side in this?
I personally, as a defense attorney, never, ever want to put the defendant on the stand. I don't think that it ever helps. The defendant is going to be cross examined by the prosecution. If there's anything they're inconsistent about, that's going to come up. Their life is going to be scrutinized, and they're just not, even the best witness, they're not going to sound great. The burden of proof is on the prosecution. My defense is always that the prosecution failed to meet their burden, that there's unanswered questions, that there's inconsistencies, that there's just not enough proof, versus putting my client on to testify and now essentially creating a burden onto myself when I don't have one. Because what jurors do, despite what the law says, once the defense puts on a case, it becomes a he said, she said. And jurors say, okay, well, this is what the prosecution proved. Here's what the defense put on. Which one do I believe more? And it's not a question under the law of which one do I believe more. It's really a question of whether or not the prosecution met their burden. So if it was me defending this case, I would absolutely, definitively not put the defendant on the stand. Of course, all lawyers are different, and certainly her lawyer has the opportunity to meet with her and know what she's like and make the decision between him and her.
And as you mentioned before, we do cover a lot of these cases where teachers are accused of sexually assaulting their young students, specifically women defendants in these types of cases. In your opinion, is there anything that schools or even parents can do to help prevent this from happening or even just monitoring it just a little bit more?
Yeah, Elizabeth, you mentioned monitoring it. That is a great point. With social media becoming so abundantly everywhere, and with younger and younger children having cell phones and having access to social media, it is crucial that parents and guardians and adult friends who have access to children monitor and supervise their online activity. If a young person has a cell phone, their text messages should be monitored. They might be thinking, oh my God, we're violating their privacy. These aren't adults. I'm not saying, show up at your 20-year-old's dorm room and go through their phone. That's certainly going to create tension in your relationship with your adult child. I'm talking about elementary school children, junior high school children, and even young 14, 15-year-old high school kids, right? They're sending naked selfies. They're engaging in sexually explicit conversations with online strangers. And sometimes they are motivated to meet people across state lines for sexual activity. Sometimes they're enticed to meet adult strangers and get abducted, get sucked into sex trafficking, get really taken advantage of. And it's not their fault. They're very young, they're vulnerable, and it is so easy to prey on children who are being exposed to social media, who simply don't know any better. And so it is crucial for parents and guardians to know what websites your child is visiting, to know which apps they have downloaded, to see who they are communicating with, and to teach them about internet safety, about social media safety, about communicating with people that maybe they don't know and the extent of those communications, about taking and sharing sexual photographs of themselves and where those photos go and what might happen to those photos. They could live on the internet forever. They could turn 30 years old and see photos of themselves at age 14 that they never wanted to live on. So these are all conversations that parents unfortunately need to have with younger and younger children. And the minute a child has access to a phone, an iPad, a computer, parents need to be aware of what that child is doing on those devices.
All right. Well, Florina, I always appreciate your insight into these types of cases. Before we sign you off, is there anything else you would like to add?
Just, this is unfortunately yet another example of a teacher not just behaving badly, but doing things that are really going to be damaging a young child's life, potentially forever. And it's unfortunate when we see this, and it is nobody's fault but the teachers. But there are things that parents and guardians can do in an effort, not foolproof, to try and prevent this kind of conduct from escalating. And so it's important for our listeners and viewers to be aware and to stay vigilant. And as always, thank you for having me and thank you for listening.
All right, Florina, thank you again for your time today. I really appreciate it. Online records show Madison Bergmann is set to appear back in court again on October 7th for a preliminary hearing. She reportedly faces a maximum sentence of up to 178 years in prison if convicted on all charges. Reporting for Law and Crime, I'm Elizabeth Millner.